Hello, everyone, and welcome back to one more session of Adraas, real-time dispute resolution process. Today, we have with us a very young but experienced advocate, Mr. Ankit Virmani. He's got a vast experience with arbitration and dispute resolution. He's a graduate from National Law University, Jodhpur, and then he joined Virmani and Virmani at New Delhi in 2015. The topic that we chose for today is Group of Doctrine, Group of Companies Doctrine. Now that's the bone of contention always. And let's bring in our speaker and see what he has to say with this. And maybe we'll have more questions or more answers. We'll know towards the end of this program. So thank you and welcome, Mr. Ankit.
Hi, Dr. Reddy. Good evening. Thank you for inviting me.
So on this Group of Companies Doctrine, where should we start? Why don't you start with the introduction on that, and then maybe you can take it forward from that.
Sure, absolutely. Since this discussion is relating to arbitration, the aspects of Group of Companies Doctrine that pertain to arbitration arise out of the question that has come before courts innumerable times, which is that if a company is not a signatory to an arbitration agreement, but is a closely held company or is a group company of a signatory to the arbitration agreement, can such a company also be compelled to join arbitration under that arbitration agreement? This issue has held the attention of our courts for several years now, and it has traveled to the Supreme Court on several occasions as well. The issue is a vexed one because you have a situation where there may be a group of closely knit companies where there is a common parent or which are held commonly by a common promoter. All these companies are joined together in a group of, in a sense, where they each have their own corporate independence. Each of them are separate legal entities under law. They have the right to enter into contract and equally the liberty to not enter into a contract or to not be bound by a contract that their sister concern may have entered into. Such a group of companies, sometimes we have transactions where multiple companies forming part of the same group will be transacting relating to a complex multi-party transaction. It could be a transaction relating to distribution of goods in a certain jurisdiction. It could be to engage in a construction. So one company may be giving a loan, one company may be giving IP, one company may be carrying out the main activity. And there are situations where you have these composite transactions with various entities involved, and multiple contracts also are there. Now, you may have a parent contract, you may have subsidiary contracts. One contract may be, say, a joint venture. In a lot of situations, you find a joint venture between two disparate entities coming together. Now, in this joint venture, you may have, under this joint venture, under the umbrella of this joint venture, where two parties have decided to start a business, various aspects of the business are dealt with in subsidiary contracts. So there may be a licensing of trademark from somebody else. A third party may be coming in to perform certain parts of the contract and things like that. Now, you may have multiple contracts because of this, under this umbrella of this joint venture, in this example. The joint venture has an arbitration agreement. But the subsidiary contract, or say the licensing agreement, which is where the parties are overlapping, but not all the same. So there may be one party which is giving a license of their IP, but that party was not a party to the main joint venture contract. Now, the joint venture contract has an arbitration agreement, but the license agreement does not have an arbitration agreement. Questions arise typically as to whether the company which is granted license of the IP, in this example, which is not a party to the main joint venture contract, but is a sister concern of one of the entities of the joint venture and has entered into a separate licensing agreement, whether such an entity would be bound by the arbitration agreement in the main joint venture contract. Now, the question in itself appears complex. It,
Let
and
me,
even the,
let me stop you for a second because the question has taken a long time to even try to get a shape. And
correct.
in this short period of time, we cannot get into a very detailed explanation of everything. If that's okay with you, impromptu, let me ask a few questions so that things may be more clarified.
Sure,
Okay?
absolutely.
So let's take one situation at a time. We are talking about, okay, let me even step back and say, what is the ultimate decision of the Supreme Court? That the group of companies doctrine applies, which means that the arbitration clause is valid, even though a company is not a signatory to it.
So the Supreme Court gives a nuanced answer. The first point that the Supreme Court says is that just because a non-signatory to an arbitration agreement may be a closely held company of one of the signatories, or maybe part of the same group of companies in that sense, does not by itself, this is not sufficient for the for that non-signatory to be bound by the arbitration agreement. Number two, the fact that it is a closely held group company is an indicator or is one factor that the court has to examine or look at while deciding whether a non-signatory company is or is not bound by the arbitration agreement. Number three, the whether a non-signatory is a party to the arbitration agreement or not has to be determined on certain parameters. Those parameters can include whether this company took part in the negotiation of the contract, whether it took part in the performance of the contract, whether it took part in the termination of the contract. So the non-signatory's role in the transaction, starting from the negotiation right up to termination, plays a crucial role in deciding whether that non-signatory can be bound by the arbitration agreement.
Let me slow down and say that bottom line is that the answer is a yes and no.
Right.
Yes, if the companies fulfill certain criteria. Otherwise, the answer is no.
Right.
Okay.
And if I may add, the bottom line is what was the intention of the signatories as well as the non-signatory. That's the bottom line. If the intention was to make the non-signatory a party, then the non-signatory can be joined in an arbitration. But if the intention was not to make the joint signatory a party, then the non-signatory cannot be made a party. Just because you're a part of the group is not sufficient. Is not a sufficient condition to bring you in.
The problems that arise are, how does one know that I have to bring in the group of company or not? When I'm entering a contract with you, I don't know whether you are going to rely on your parent company to bring in investment, as you yourself has said, or the IP, or some other expertise. I don't know what's happening between you two. All I'm doing is dealing with one person who could be titled general manager or CEO or even much lower than that, who's just signing on the authorized representative, just signing on the contract. I don't know what's happening behind. How do we proceed from that?
That I think that's a very, very pertinent question. If the person on the other side, so firstly, the burden. The Supreme Court judgment clearly says that the burden is cast on the person trying to impede the non-signatory. So it is the person who's trying to impede a non-signatory has to discharge that burden of proving that the non-signatory is actually bound by the arbitration agreement. So if this person who's trying to impede the non-signatory is the counterparty, then the counterparty will be only doing it if he has knowledge. Because if he had no knowledge of what is going on behind, then he would not be wanting to impede a non-signatory. Therefore, in a counterparty situation of the kind that you mentioned, it will mostly be a situation where the counterparty knows what is happening and the counterparty has, say, entered into multiple agreements, main agreement with one party, but subsidiary agreements with some of the other ones, some having an arbitration, others not having. In that scenario, definitely he will have to discharge that, and counterparty will have to discharge that burden and show that even though the parent which was bringing in funding or IP or whatever other ancillary things is the person who was so closely connected with the performance of the main contract, which has the arbitration agreement, so as to show that the intent of all parties was that this other person, the parent or whoever the other entity is, should be bound by the main contract also. So the burden is cast in that fashion. If the burden was on the other, sorry, if it was not the counterparty, and say it was the main company itself which had to bring in its own subsidiary into the arbitration, then of course their job would be, I'm guessing, a little easier. But the counterparty there can always say, look, if you bring in, if you are trying to, so this happens sometimes, that the ancillary party is wanting to initiate arbitration under the arbitration clause, where the ancillary party is not a party to that arbitration clause. There, the counterparty will then say, look, I don't know you. You are not performing any obligation under the transaction. You may be helping your own entity or your own affiliate, but you are not party to this transaction. So in that scenario, perhaps the ancillary party may not be able to step in as a party to the arbitration agreement itself, if it has played no role in the inter-parties transaction.
Let me say one of the practical things that actually happens is the due diligence in these cases happens after the dispute occurs, not at the time of entering into contracts. So at the time of entering into contract or during the performance of the contract, I don't know what's happening behind you. But once there's a dispute, then I start digging in, I come to know certain things. And these may be available from the balance sheets, or it could be from your own website or some other source. And that's when these issues crop up. But let's deviate a little bit and say that if there are 2 or 3 groups who have formed a joint venture, 2 or 3 different entities that have formed a joint venture, and the joint venture has participated in a bid. So obviously the joint venture is bound by these arbitration clause. But the joint venture by itself is an independent entity which may not have any assets. When the realization of the award or degree, whatever that I have to receive, at that time I want to go after the parent companies, but they have not been included into this arbitration at all. So how do I go after them when I did not know all these details? So these are some of the practical issues that I'm just popping up and saying that there are too many complications, too many variables, and sometimes the answer is not that clear.
Yes, the solution is not elegant, for sure. First, I just wanted to address the first point that you made, that a lot of times the due diligence is done subsequently, and because of that, some things come out at a later stage after entering into the transaction. Now, let me take a scenario of that nature. Suppose suppose there's an investment contract where an investor is coming into and joining, or a strategic investor doing a joint venture with an existing promoter. The investor puts in money into the company, only later on to find out that the money has been siphoned off to a related party by the promoter. That related party otherwise did not have anything to do with the transaction. In that scenario, the investor, if he initiates arbitration, even after coming to know that the money is siphoned off to the related party, if he initiates arbitration in his contract with the promoter, with just these facts, he may not be able to implead the related party, because the related party has played no role in the transaction as such. So the test always is whether they've played a role in the transaction, in the negotiation, performance, termination, and things like that. If that has not been the case, and they have simply taken away the money which came into the company as a result of the transaction, perhaps you will not be able to implead them in an arbitration, though you may have other remedies against them. There is, however, one avenue available where, under Section 9 petition for interim reliefs, one can even add non-parties, not just a party to an arbitration, non-party, and maybe there try and get some relief against non-parties to the arbitration agreement. I have been part of one such dispute where we managed to get some orders against non signatories, not on the principle of Group of Companies Doctrine, but on the basis that under Section 9, the subject matter of the arbitration needs to be preserved. So on those principles. Now, coming to the second aspect. Sorry, can I request you to repeat the second bit of remarks for me?
So yes, the thing I was saying is when there are no assets in the joint venture,
Yes.
how do we go after the parent companies?
Yes. So there is some case law on Section 35 of the Arbitration Act where enforcement of the award was sought against person who was not signatory to the arbitration agreement. The court has allowed it. Again, the principles remain the same. Can we show that party against which you're proceeding had agreed to be a party to the transaction, to the underlying transaction, and hence to the arbitration agreement? And on that basis, enforcement has been permitted. However, the question, as we've discussed, will remain a vexed question, and recovery will nevertheless not be easy at all.
As a let's take one more scenario where we are dealing with a, I'll say, like a brokerage kind of a structure, where one company is just managing. They don't have any factories, they don't have any machinery, manpower, or anything. There'll be just one person who's called the managing director, and there'll be one secretary or assistant. That's it.
Right.
So they will be dealing with you, they'll sign the contract with you. Whatever work they get, they will give it to their, I'll say, the partner company, even though partner includes this person and somebody else. And they get all the work done and they give it to you. So they're just like a courier, taking it from here and giving it to the other guy, taking your money and giving it to them. So in those kind of companies, now this is not a joint venture. The directors and shareholders may or may not be the same. How do we deal with those situations?
This is one aspect where I don't agree completely with what the Supreme Court has said, where Supreme Court actually in Cox and Kings, the latest judgment, Cox and Kings versus SAP India, the Supreme Court has taken a view that Group of Companies Doctrine is an essential but not sufficient condition. Now, I don't agree that it is essential also. Because if you actually look at their analysis, it doesn't matter whether it's a group of companies or not. What matters is the underlying intention for the non-signatory to be bound or not bound. Whether they are a group company or not is only an indicator. But according to me, it's not essential. Why should it be essential that it should be a group company only? In your example, it's a perfectly legitimate example, I think, where it may not be a group company. But still, they are working closely in this contract. And if that is the case, and if the other party has shown or has acted in a manner where it has benefited from the contract, in fact, there is some precedent also to suggest that if a party has benefited from a contract, has got direct benefit from a contract, then equally it should have obligations or it should be bound by the arbitration clause under that contract as well. So there is some authority to support, recovery even in a case of the nature that you mentioned against the non-signatory as well, depending, of course, on the exact facts of the case. But the Supreme Court, I feel, has gone a step too far in saying that Group of Companies Doctrine to establish that they are part of the same group is essential. I think I don't agree with it.
We can always get innovative with certain ways of doing things. But as a closing remark, I want to ask you a question on this from the taxation point of view. If the tax departments rule that the transactions between two companies are akin to a group of companies, something similar to that, they are closely related transactions between these two companies. In those cases, can we take that as a, let's say, precedence to say that these companies are group of companies? Now, I know that arbitration and legal matters are separate and taxation are different. But I'm importing the tax department's views into this litigation and saying that since the tax department ruled that they are so closely bound, allow me to implead these parties also. That's a closing remark, and you can take it from that.
So that's a very interesting point because the Supreme Court in Cox and Kings directly deals with a situation where parties, there are previous precedents also, where if you are so closely connected, say one company controls everything about the subsidiary, it's a wholly owned subsidiary, everything about the subsidiary is fully controlled, that other company has a complete control, and they're in that sense one is an alter ego of the other. Or they can be considered as single economic entity for all practical purposes. I'm not sure if it'll attract taxation in that sense or not, since I'm not a tax expert. But in a scenario of a single economic entity, also the court has now clearly held that by itself, being a single economic entity will not attract, will not mean that the non-signatory becomes bound by the arbitration clause. For you to show that a alter ego is also bound by the arbitration clause, you need to fulfill the test of showing the intent of all parties to ensure that non-signatory is actually bound, which is through their conduct. The intent has to be, the court has said the intent has to be seen through conduct. And therefore, just because one is an alter ego of the other is not sufficient to attract arbitration to a non-signatory.
I guess that kind of sums up that advocacy is more powerful than any one particular thing where we can import something from one to other, or we may not. But the group of companies doctrine is an ocean, and we are not even scratched the surface. There are more questions, more topics that we need to discuss, but it's not possible in this one session. But it was very interesting, different perspectives and the current status from your side. And I thank you for your time. And hopefully we may have one more round on this, and we can have the group of companies doctrines, let's say season 2 with you.
Yeah, absolutely. Anytime. Thank you so much, Dr. Reddy.
Thank you, Mr. Ankit.